Rallos versus Felix Chan and Sons Realty Corporation. Facts: Concepcion and Gerunda Rallos were sisters and registered co-owners of a parcel of land known as Lot number 5983 of the Cadastral Survey of Cebu, covered by Transfer Certificate of Title number 11116 of the Registry of Cebu. They executed a special power of attorney in favor of their brother, Simeon Rallos, authorizing him to sell such land for and in their behalf. After Concepcion died, Simeon Rallos sold the undivided shares of his sisters, Concepcion and Gerunda, to Felix Chan and Sons Realty Corporation for the sum of 10,686.90 pesos. New TCTs were issued to the latter. Petitioner Ramon Rallos, administrator of the intestate estate of Concepcion, filed a complaint praying, number 1, that the sale of the undivided share of the deceased Concepcion Rallos in Lot 5983 be unenforceable and said share be reconveyed to her estate. Number 2, that the certificate of title issued in the name of Felix Chan and Sons Realty Corporation be cancelled and another title be issued in the names of the corporation and the intestate estate of Concepcion Rallos in equal undivided shares. And number 3, that plaintiff be indemnified by way of attorney's fees and payment of costs of suit. Issue: whether or not sale was valid although it was executed after the death of the principal, Concepcion. Held: no. General rule is enunciated in Article 1919 that the death of the principal extinguishes the agency. That being the general rule, it follows a fortiori that any act of an agent after the death of his principal is void ab initio unless the same falls under the exception provided for in the aforementioned Articles 1930 and 1931. Article 1931, being an exception to the general rule, is to be strictly construed, and it is not to be given an interpretation or application beyond the clear import of its terms, for otherwise the courts will be involved in the process of legislation outside of their judicial function.